The uMkhonto weSizwe party has strongly rejected the judgment of the Western Cape High Court, which basically stands against the appointment of its parliamentary leader, John Hlophe, to the Judicial Service Commission. The MK party says the court ruling gives the DA and the courts the right to veto the decision of the majority of citizens. The Western Cape High Court declared that it was unconstitutional and invalid for the National Assembly in Parliament to approve impeached Judge John Hlophe as a member of the Judicial Service Commission. It also ruled that the appointment should be set aside. Hlophe was found guilty of gross misconduct after he allegedly tried to influence the justices at the country's top court in a case that related to former President Jacob Zuma in 2008. The DA approached the courts arguing that Parliament acted irrationally when it agreed to Hlophe's recommendation by the MK party. Well, the Democratic Alliance has hailed the court decision.
That we cannot have a former judge who's impeached because of his misconduct that has been proven in tampering with the outcomes and the dealings of the court, serving in a Judicial Service Commission, a commission that is very important, that deals with important matters such as the appointment of other judges across the land. So it is a victory that we are happy and welcome as the Democratic Alliance, and we're happy that we've fought in the right direction. Happy we were able to uphold the dignity and the effectiveness of the court system.
Well, let's discuss this further now. And Freedom Under Law legal consultant Chris Oxtoby joins us from Johannesburg tonight. Chris, good evening to you, and thank you very much for your time. The MK party has already reacted to this judgment, putting out a statement which essentially says that this to them is a representation of everything that is wrong with this current constitutional arrangement. I just want to extract a line from that statement, Chris, and I quote now: "It cannot be that 3 unelected judges who are not lawmakers but interpreters of the law allow a racist minority to subvert the will of the people." How do you respond to that?
Well, I mean, let's just pick up on one aspect of that statement, which does actually acknowledge that judges are interpreters of the law, and that in our system, that law, the supreme law, is the Constitution, and the Constitution sets out requirements by which all other laws must be consistent. It sets out requirements that lawmakers such as Parliament must follow. And in this case, as the court has found in today's judgment, there are requirements that the Constitution puts on that process, which have to be followed. So in fact, the judgment is a really important affirmation that, as the court's found, the National Assembly was not free to disregard the fact that former Judge Hlophe was removed from office for gross misconduct. That had to be taken into account, and that impacted on his suitability for the position. So the judgment is, I think, an extremely important and valuable one, rather than the criticisms that have been leveled against it.
Chris, the MK party goes further than this. And I just want to once again extrapolate from their statement, because it's almost as if they are saying at some point this legal system, the current legal system in South Africa, has got to be completely replaced, because they are saying, in fact, these are their words: "We call on all freedom-loving South Africans to unite behind the clarion call of the MK party to fight the present oppressive legal system and replace it with true justice and genuine democracy by any legitimate means necessary? Those last 3 words, or 4 words perhaps, any legitimate means necessary. What do you think the MK party is talking about here?
Look, I haven't heard that statement before now. I hope that will be read in the context of saying that, legitimate protest, legitimate disagreement. We can disagree with judgments, with decisions. There is an appeal process which might be followed. I would be very cautious though with this kind of language about overthrowing a legal system, and the idea that true justice and freedom and other virtues are found in overthrowing a constitutional system which we all know came about in a very particular historical context, and serves a very important role. Our history, I think, suggests that pure majoritarianism, unconstrained power causes a lot of problems. And I'm not sure, and that's, this is a political party that obviously is not in itself a majority party in any event. So I would hope that statement means nothing further than that people are entitled to disagree and express a disagreement, and that any further avenues in the legal process can be followed. But I think the idea of sort of upending an entire system by which the country is run, I think people should stop and think very carefully about what that might actually entail before rushing to endorse it.
It appears that there doesn't seem to be appetite to take this perhaps to the highest court in the land. You will know that the leader of this party is a very litigious person, and does it strike you as interesting that they're not willing to engage the legal system? If anything, it is to upend it, as you say. Failure to get this to the Constitutional Court, which is the apex court, do you think that this is essentially the end of the road as regards Dr. John Hlophe serving on the Judicial Service Commission?
Yeah, I mean, if there's, if there's no further appeal, then that will be the end of the road as far as the legal process is concerned. I would be a little cautious about dismissing the possibility of an appeal at this stage. I'm not sure what, whether Dr. Hlophe himself would take that same view, because of course both he and MK Party were cited as separate litigants in the matter. So I think what we're hearing in the statement, I think it resounds with what that political party has been saying in election campaign messages. Means that we're not going to see anything further in the legal process or not. I think we would have to wait and see. I do think one factor is that my impression, having briefly read the judgment, is that it is a strong and impressively written judgment. So I don't think it will be easily overturned. But that's the nature of a system where we're governed by the rule of law, that sometimes there are decisions that go against us that we might not like, but that we have to accept and move on from it. And I think lastly, it is just important to mention the judgment is very specifically directed at the unique circumstances around former Judge Hlophe and the factors that make him not suitable to serve on the JSC. There's of course nothing stopping the MK Party from putting a different candidate forward to be a member of the JSC. That's entirely open to them to do.
Yeah. Finally, Chris, you speak of the unique circumstances that the court judgment draws on as regards the recent past of Dr. John Hlophe. If he had been allowed to serve on the Judicial Service Commission, I remember at the time of the petitioning of the courts, the kind of strategy that was employed, or the kind of language employed to say judges would find it difficult to sit in front of him and be be questioned by him on whatever matters, given what had happened to him in terms of him being impeached. Had he made it onto this 6-member Judicial Service Commission, what would have been the consequences, you think?
Well, I think there would have been one very immediate consequence, and that is that in the October 2024 interviews, which were the ones that came up immediately after his designation, they were interviews for effectively his replacement as the Judge President of the Western Cape High Court. And those, anyone who followed that process will know, were some quite difficult and torturous interviews with, I think it's fair to say, a significant undercurrent of some difficult issues that had arisen while Dr. Hlophe was still Judge President in that court. It would have been enormously difficult to imagine how those interviews could have realistically proceeded with him sitting as a member of the JSC. I mean, to give just one example, the Deputy Judge President, Patricia Goliath, had a pending complaint and counter-complaint between herself and then Judge Hlophe before the JSC when he was removed from office. So it would have been very, very difficult to see an interview properly going ahead in that circumstance. I think the broader underlying question that the court picks up on in the judgment is the issue that, as the court puts it, Dr. Hlophe has not accepted that he did wrong. He has continued to disagree with the reasons for his removal from office, and has indicated that he would encourage a situation where other judges felt free to act as he had done in the circumstances that led to his removal. And I think that would have raised enormous problems about the kind of approach and the kind of criteria that we're taking to appointing our judges, given that the JSC and the courts have consistently said that, in fact, that conduct was grounds for removal from office. So all in all, it would have created, I think, enormous and significant problems that we are, it's a very good thing that we do not have to grapple with.
Chris Oxtoby, thank you very much for your time tonight, a legal consultant with Freedom Under Law.